Are real estate agents funded to use interpreters, and is there a requirement for them to translate documents? It's a really good question for multicultural community members and renters. So the answer is that there is free translation services. So TIS is one of the services that provide free translation services that comes through the Australian government, and they will provide interpreters for free. So it's not necessarily a funded thing. Is there a requirement for them to translate documents? The short answer to that one is probably not. TIS does allow allocations for some people. So if you're newly arrived and going to be a permanent resident, I think there's an allocation currently of around 10 documents that they can translate over about every 2 years. They may not want to use that document translating budget for their rentals. Agents have also got a responsibility under the professional conduct regulation, so that's the estate agent professional conduct rules, that they act fairly and honestly. And again, when we're getting essential services, which include things like renting, there's also an obligation for them to make reasonable adjustments. So I would expect that good agents would recognise when someone has a significant language difference and the English isn't their first language to use those interpreter services. It is always incumbent, and it's certainly common practice that if you know or are aware that person does not speak English or is not fluent in English, that they should seek those documents to be translated as well. So things like notices of rent increase, breaches of duty notices, notices to vacate, and even the rental agreements. And also now the new rental application form, there are translation contact information there, and it's a good idea for a renter to seek their own independent advice and not necessarily be reliant on anything that's being translated by a real estate agent if they are multilingual themselves. So there are translation services that are for free, and they should be taken up and used as much as possible. It may be possible that if it's a consistent issue, that it could be complained to Consumer Affairs Victoria, and potentially even VCAT may be able to address that as an ongoing ancillary feature of an order if there's ongoing issues around things like repairs, that the member is within their authority to make an order that, you know, the real estate agent uses appropriate translation services to make sure the renter knows what's going on, because ultimately it's in everyone's interest to resolve those sort of disputes. Next, we have, what instances do renters have to pay a fee at VCAT? It's a really good question. So the presumption is that most renters will have to pay an application fee. Currently, it's $74.10. It gets indexed, or it means updated each year. So it'll probably by July 2026, it might be up to about $77 or somewhere around there. Most of the clients, particularly for frontline service workers, where you're working with clients that are on healthcare cards or otherwise in financial hardship, they'll be eligible for fee waivers. So that fee waiver might apply to the application fee, but it might also apply to other things such as a summons for oral examination, which means getting a witness to come. There are costs associated with getting someone to come to the hearing, so we don't do that sort of off the cuff. It's only really when it's needed. But there is recognition when people can't afford things for themselves. We really encourage people to talk with their clients around the hardship if they do need to make an application, and that's a decision of the principal registrar of VCAT about whether they'll waive that fee. In terms of any risks or costs at the end of it, there's a strong presumption, particularly in the residential tenancy list of VCAT, that people bear their own legal costs. So even if a landlord or a real estate agent has a lawyer representing them, you won't have to pay those legal fees unless you've really caused a disruption in the proceeding in terms of promising to bring documents and you didn't, or doing things that the tribunal thinks merits that you should be responsible for the costs, and that's under Section 109 of the VCAT Act. But in 99% of cases, the tribunal recognises that renting is a really important service and people shouldn't be afraid of legal costs. And as we've spoken today, the Rental Dispute Resolution Victoria is a free service and there's no costs at all for using that. And that includes getting consent orders through the member. And that's a wonderful way of getting an enforceable agreement and not having to pay any fee at all. We have next, how do we support renters who face backlash from landlords after they've asked for repairs to be done? For example, when they receive a rental increase. It's a really great question. It's a really common fear for a lot of renters that if they put for repairs to be done, the landlord will give them a notice of rent increase. Rent increases can only be done for the most tenancies every 12 months. There's an exception if you've been a periodic tenant since the 19th of June 2019. It can be every 6 months. In some of the other accommodations, such as SDA, so specialist disability accommodation, it's also every 6 months. The principle of rent increases is described in the law as relating to properties that are of like nature. So when we talk about this idea of a backlash, traditionally people were afraid of getting evicted. If you're asking for the property to be put in good repair, that's what the law requires. So there shouldn't be any justification for a rent increase just because you've had the property put back into good repair. And this is really where we need renters to be out there testing the law and to make those reports and requests to Consumer Affairs Victoria to say, hey, the money I'm paying is as if the property is in good repair. And one of the things the Consumer Affairs Inspector can do is to take into account the lack of good repair and also whether or not there's any outstanding orders. So if a renter went and got, say, for example, an order for their air conditioning to be fixed and it hadn't been fixed, or even if it had been fixed, for a period of time, you'd be looking and saying, hey, that's something where I'm paying money and I'm not getting the full value for it. So in terms of that idea of backlash, the fear of getting evicted, we've now lost the no reason notice to vacate. Well, we haven't lost it, it's gone. It's been deliberately removed because of this issue. We know that, in many cases, there are landlords that would try and displace renters that use their rights, and that's become harder and harder for rental providers, and that's the right direction. We need to make sure that if you're providing an essential service, you follow the rules and that everyone is able to use their home and not have to get caught up in lots of red tape and, going to VCAT just to get, your house working the way it should be. So if you do get what you feel is some sort of backlash, reach out, have a chat. It may be how you're treated. It may be that they're trying other actions or they make claims for compensation that are not legitimate. Again, we look at our estate agent professional conduct obligations to make sure they're acting fairly and honestly. We have here next, do you have rental rights if you are not named on the lease agreement? A really great question. So assuming that there is a written agreement, if you're not named on that agreement, you're likely not to be a co-renter. And that would mean that you probably don't have the protections of the rental laws in Victoria. Legally, this is often described as being a licensee or a boarder. So I might be a renter living in the house and I might have my friend Amy, and Amy comes and lives with me. Now, how that relationship works is that I would be the renter and Amy would be the licensee. If Amy and I had a fight, I might be able to lock Amy out. But it is really important to recognise as well in the context of family violence, that could be different. So if Amy was my partner, a person that's not on the lease can still make an application to put the tenancy in their name. So it's really important that just because someone is not on the lease per se, that we look at the relationship and we consider whether or not there's personal violence or family violence going on and some of the background in relation to that. So it is important that it's not a black and white rule. But if someone is a licensee, it is a difficult area because there's not any legislation that says this is what the licensee's rights are, and it is a bit of a gap. We're seeing more and more people couch surfing. So that means, you might just be in a room, it might be a share house, but you don't have your own room, or people can come into your room whenever you want. And that's often a really complicated question as well, if there's no written agreement, who is on the agreement per se and who is not. If you're transferring or assigning a tenancy, giving someone else an interest in the property, that's the legal term for it, you want to make sure that it's really clear. In share houses, if you're on the agreement, you're jointly responsible with everyone else on that agreement. So if one person goes and does a whole bunch of damage, like punches holes in the wall and it's like $2,000 of damage, potentially that's in all people's names. So sometimes it's in the renter's interest to want to be protected from being evicted, so they're on the tenancy. In other situations, they're like, oh, I don't want to be on that agreement because of all the damage here. I'd rather be a licensee and I'll just shoot off. What would encourage most people to do is, if you're not sure whether you're on the agreement or not, is to seek some advice. The law requires the landlord to have given their written consent for you to be assigned or transferred on or off the lease. Often that can be a really confusing thing because some people were on a tenancy and they will choose to leave and they think that they're off the lease. Even if you leave the property, if your name was on the original written agreement and it hasn't been transferred, you may still be liable if there's rent arrears that rack up, which could result in a tenancy database, or there might be a debt for $3,000 that could potentially still be enforced against you. Tenants Victoria doesn't normally advise in relation to inter-renter disputes or disputes between renters, but it is important to have a sense of what does joint responsibility or liability mean and to seek advice. If you can't seek advice through Tenants Victoria, many community legal centres will be able to give you some general guidance on that idea of whether you are on or off the lease. But certainly it's worth reaching out to Tenants Victoria just to identify what the situation is and what your rights might be. The next question we've got is, how do tenants contact urgent repairs when there is a public holiday? It's a really good question, very practical. It can be difficult. The emergency contact number that should be in the lease should be contactable even on a public holiday. There is a provision in the law that allows a renter to try and reach out to their landlord. If they're unable to contact them or get action started, that they can actually spend up to $2,500, including GST, to get those repairs done and then seek reimbursement. We often don't encourage renters to do that unless there's a serious safety issue, because then you're chasing money. So public holidays, the call-out rates are often very expensive. The law doesn't actually state how quickly an urgent repair needs to be attended to. What it does state is that if there is an urgent repair, VCAT needs to hear the application within 2 business days. You'll probably note that RDRV is likely to be closed on public holidays as well. So you really want to look at the level of danger to make sure the property is safe. You want to look at the level of urgency. With reimbursement, the law says that a renter is only going to be reimbursed the reasonable costs. So if it's on a public holiday, say, for example, the evening of a public holiday, and you could wait until the next business day, it may be considered reasonable to wait. It depends on the circumstances. I would suggest reaching out in anticipation of this issue, because during a public holiday, Tenants Victoria is probably closed too. So it's really a bit of a risk that you can spend money and seek reimbursement, but there's no guarantee you'd recover it. You would definitely want to make sure that you've got some written evidence to show that you've attempted to contact that emergency contact number, so you can show to the tribunal, if everything doesn't resolve, to say, look, we tried, they should have had an emergency number, there wasn't, and it's reasonable for us to be reimbursed the full amount of money we've spent. The next question is, what happens if you are dealing with a tenancy issue in RDRV, but you're experiencing family violence? Really, really important question. So at the moment, we don't have any guidelines in relation to RDRV, but we often are discussions with RDRV about best practice. So there may be some situations where the family violence is being committed by someone else that's on the rental agreement, and it may not be appropriate for that to be heard through RDRV. For example, if there's damage being done to the house in the course of family violence, and the victim survivor renter shouldn't be responsible for that, it may not be appropriate for negotiations in that context, and it would be best heard by a VCAT member. Equally, we don't want people who are victim survivors of family violence to feel that every time that they go to ask for repairs done that might not be related to family violence, that they're going to get pushed into a formal hearing. So in each case, it might be unique, and we'd encourage people to talk to the RDRV resolution coordinator about the nature of the family violence, if it's going on, and about whether or not it's relevant to their application and what they want to do. So best practice is to make sure that we are open and able to talk around the existence of family violence, and that may include things not just of physical harm or damage. It may also be around coercion control. It could be around access to documents. And certainly we know in a lot of situations the ability to control emails or monitor emails, whether the person is on or off the agreement that's using family violence, are all relevant considerations. So each case will be a little bit specific, but I think the important thing for us as support workers and with working with community and even our friends and family, that we're able to talk around family violence openly and to work out what the best practice is and what's the safest practice, and to work out what the resolution that we want in those proceedings. The next question here is, in the area I provide support, many communities are on Centrelink who are living in rentals without a proper lease agreement. They are terrified to rock the boat with the landlord. What can we do to support these renters to get them a proper lease agreement? A really great question. The first thing with a lot of work that we do with multicultural communities is to try and dispel the myth that if you don't have a written agreement, you don't have any rights. That's not right. So what you do have is that as long as you can show it's your primary place of residence, you're paying some rent, and there's no other exemptions in the Act, like say, for example, that it was part of my job, then the residential rental laws will still apply to you. So it might be that you can show photos of you living in the house. You might be able to show a regular transaction. Oops. That's okay. Go get. It's okay. The next question is, in the area I provide support, many communities are on Centrelink who are living in rentals without a proper lease agreement. They are terrified to rock the boat with the landlord. What can we do to support these renters to get them a proper lease agreement? So the good news is that even if you've got an oral agreement, as long as you can show it's your primary place of residence, that you're paying rent and there's no other exemptions in the Act, such as the property is part of my employment, then the rental laws will apply to you. So with a lot of multicultural communities that we work with, it's really important that we dispel that myth of just saying because you don't have a written agreement doesn't mean you don't have any rights. You do. So when we're talking in a situation, it might be someone, they live above a fish and chip shop, for example, and they don't have a written agreement and they're paying everything in cash. What we might look to do is to say, can you show me regular withdrawals out of your bank? Can you show me photos with your friends hanging out in this particular house? All the things that would suggest that this is your home and this is exclusively yours. If we can do those things, we can actually apply to the Victorian Civil and Administrative Tribunal for an order that the landlord has to provide a proper and written lease. Even if we don't have that, all of the standard terms in the prescribed rental agreement will apply to you. Your rights are the same. The landlord cannot just turn up and change the locks. So it's really important that if you're not sure about whether or not the rental laws apply to you, to reach out and seek advice. So the next question is, if your rental application information is deleted after 3 years, what does that mean in terms of providing referee information on the rental application? So the new laws provide that your rental information needs to be protected, but not only does it be protected and can only be used for the purposes of applying for the property, but also it needs to be destroyed or permanently de-identified after certain time limits. So as the question suggests, they can keep your personal information for up to 3 years after the tenancy ended. So that means that you should be able to use that information as a referee to get to your new property. If it was, for example, a second referee and it was older than 3 years after you'd moved out, you could probably give written consent to the landlord to keep it for a longer period. But given that they've probably been dealing with you for more than 3 years, hopefully that they would remember you. In any event, the new provisions, sections 505BA through to capital E, will provide for a framework, but there's also privacy principles that exist in terms of federal legislation under the Privacy Act. So there may be circumstances where you can approve or allow them to keep that for longer. If not, you can put the information down and see how you go. But it's really important that we also know that when we do apply for a property, if we're not successful, the law now requires the rental provider or the agent to delete that information or permanently de-identify it after 30 days, unless we give them written consent otherwise. And the written consent that can be that they keep it for 6 months. So you might be going through the same agent to apply for a number of properties, and that way you don't have to keep on giving that information over and over again. Okay. The next question here is the Private Rental Assistance Program, also known as PRAP, is not in line with the current bond costs, meaning many people are ineligible for the program. What are the other financial options to support people at risk if they cannot get PRAP? It's a really great question. So there are PRAP guidelines which set out when someone will be given additional funding in order to keep the tenancy going if there's certain events where, for example, they may have fallen into rent arrears. It is a real issue. It's certainly known within the Tenancy Plus framework. So that's the advocate services that advocate for public housing residents and also community housing residents. In terms of finding other financial options to support the person, there are specialist programs. And often this is where I'll run off to a financial counsellor and say, hey, I've got this particular person in this situation. Do you know of any financial services? So it might be because it's a family violence situation that there may be additional money through a particular funding stream. So it is difficult, and this is where expert knowledge from financial counsellors probably comes in. Tenants Victoria does also offer financial counselling, and you don't need to be a client of our legal service. They can be an independent person as long as they're renting. So I strongly encourage you to jump onto our website to look at some information and also some of the contact links if you're looking for financial counselling referral. The next question we have here is, we are seeing many complex issues arising in specialist disability accommodation or SDAs. Where can frontline workers go to get more information around renter rights living in this accommodation type? It's a really great question. So in around 2020, the government made the initiative to move the disability accommodation framework from the Disability Act into the Residential Tenancies Act. And so that actually now means it falls under the responsibility of Consumer Affairs. There are not many programs or services that specialise in specialist disability accommodations, but it has a lot of similar hallmarks to the Residential Tenancy Act and how it operates. The main services that probably can provide support would be Villa Manta, Mental Health Community Legal Centre, and Tenants Victoria. Unfortunately, there are very, very few cases or decisions that have gone through or gone before VCAT to give us greater insight as to how some of the SDA framework operates. In particular, when someone is starting a residential tenancy or an SDA agreement, they're given an option. They may be given an option. They may be given a normal rental agreement, or they may be given an SDA agreement. And unfortunately, at this point, renters don't seem to have a clear choice between which agreement that they want. Some SDA providers may only offer a regular rental agreement. Some SDA providers may only offer the SDA agreement. The SDA agreement tends to have better supports and obligations around when there are complex issues or conduct arising where the SDA provider may want to evict. And so it's really important, particularly for this cohort of people, that they don't just leave when they see a notice to vacate and see a termination date. They need support, and we need to be around that community and in those services and around those facilities to make sure that people are accountable, to make sure that the NDIS money is being spent appropriately, but most of all, to make sure the client is in control of their own life. So in terms of reaching out, Villa Manta, Mental Health Community Legal Centre and Tenants Victoria are a good starting point. The next question here is, the unaffordability and highly competitive nature of the private rental market creates compounding barriers for people with disabilities. What do you see as the key levers to make a fairer system for renters on the disability support pension? A really good question. We've spoken a little bit around discrimination, and discrimination when we're talking about access to fundamental services, human rights for housing, it is difficult. And we have social housing, we have community housing, but we also need to make sure that that private stock is available and ready for all members of our community. So I think one of the key levers is really around recognising that people can share their stories around how discrimination operates. We know with modifications, if I'm a person with a disability, I might have NDIS funding, I move in, I need to get modifications done to the property. It's a travesty that when I have to move out, my ramp might have to get removed when there's other members in the community that would benefit for it. So at this point, that's kind of how the law's operating, is that I have to leave the property back the way that it was, save for any fair wear and tear. So in terms of the key levers, it's really amongst us as part of the community to identify what do our housing needs look like, and how do we recognise the significant harm that lack of housing can take place. So we now have a rental agreement where they don't have to ask us lots of information, or they can't get to ask questions that are discriminatory. So we had that since 2021, where the law says you can't ask about any protected attribute unless they provided a written statement as to why they needed to know that information. Now the government's gone a step further to make sure that when I put my name on that application, they don't need to know whether I'm going to need a wheelchair ramp. They don't need to know whether I need a sensory room. They don't need to know really anything other than I can pay the rent and look after the house. So I think probably the most important thing as we've got new laws is to make sure those new laws are working for us and for our community, and that when something isn't working, we're able to share that with ministers. We've seen the minister today really open the door to say, tell me your story. It's really important. They're willing to make those changes now, but they need to know what's working and also what doesn't. The next question here is, the rent special account is not available until the RDRV member makes that available. So probably important just at the beginning of this question, when we talk about RDRV, that would be a resolution coordinator, and a member would be someone sitting at VCAT. So I'll continue the question. We have seen instances where the RDRV have cautioned the rental provider that they will use the rent special account if they don't action the repairs. However, we still see inaction for months, but during this time, the renter has been still paying rent to the landlord. What can we do in this situation? It's a really great question. So it's important to remember that even without the rent special account, if the renter's been paying money and they haven't been getting full benefit for those services, they're entitled to compensation. So the rent special account is essentially an extra incentive to say that if you haven't done those repairs and you've been told to do them, you won't get any rent money until we're satisfied. And that's often a pressure if the property's got negative gearing or if there's a mortgage that's being paid. Not having that rent coming in to pay the mortgage, well, the banks are pretty onto how that works from there. So it's really important that when we go to RDRV, we can negotiate. And if it doesn't resolve at that point, the VCAT member can give permission. So I would be given permission from the VCAT member to say, yes, you can pay your money now to Consumer Affairs. They will hold it on trust until the VCAT member is satisfied that it'll be done. Equally, if that's not done for any reason, you can still make that claim for compensation. The benefit of the rent special account is that while the money is being held in that account, the renter can also claim for that money to be paid directly back to them rather than having to pursue the landlord for that money. So the delay or the resistance of the rent special account, because the rent special account's been around for about 30 years. It's been around for a long time. But in 2021, the government took the initiative to make it a much stronger obligation that if a renter asks for the rent special account to be used, they need to allow the renter to use the rent special account unless there's a really good cause why that shouldn't happen from the landlord. So it might be something like, it's a serious medical bill that has to be paid. So in that situation where you've applied to the RDRV, I'd be of the view that unless we hear otherwise from the RDRV, they're not able to make that order unless parties agree to it voluntarily, and that would be a consent order. But it's okay to say, look, the landlord's not been doing these repairs. I've been through repair requests multiple times and they don't do what they say they'll do. I'd like this to go to VCAT, and as part of that application to VCAT, I'd like to use the rent special account. So the next question here talks about when the VCAT member has got a repair application before them, and often the VCAT member will use the rent special account as a way of essentially trying to convince the rental provider they need to do the repairs. Months later, in the situations, the repairs are often not done and the renter's not being given access to the rent special account. What do we do in this sort of situation? So probably the most important thing is that when you ask for repairs, the standard repair order will have in it saying, if the repairs are not done by this date, write back to us, or what's called renew your application. And as part of that renewal, the VCAT will allow you to claim an ongoing rate of compensation. So that might be for every day that you haven't fixed the oven, the renter will get $25. And that just continues as a deduction. It might be a deduction against the rent. It might be an ongoing rate of just compensation entitlement. And so there's a range of options. Ultimately, if a landlord just refuses to do the repairs and there have been orders made, it's an offence under Section 480 of the Residential Tenancies Act that can be reported to Consumer Affairs Victoria. And there's also, which is pretty rare but can be done, it can be registered in the Supreme Court. And so you convert a VCAT order into a Supreme Court order, and there can be very serious costs and consequences for a landlord that just blatantly refuses to do the repairs. So while the renter may be experiencing harm in that sense, it's always important to make sure that we look at our orders and we go back to VCAT and say, hey, they haven't done what you've told me, because VCAT does have options to enforce and make sure that everyone follows the law. The next question is, do CAV and the RDRV review rent increases in supported residential services? If not, where do you go to challenge these? It's a really great question. So in the Residential Tenancies Act back in 2020, the Disability Act was moved across into the Residential Tenancies Act, and that's specialist disability accommodation. There's also another type of accommodation mentioned here, which is supported residential services, and it used to be under the Supported Residential Services Proprietor Act. In the last few years, that's moved across into the Social Services Regulation Act, and that's where we'll find the legislation and the laws relating to supported residential services. As the question suggests, there's not a clear process like there is in the RTA around rent increases. Section 225 of that Act tells us that if there is going to be an increase in the service fees, as they describe them, that the renter needs to be given 28 days notice. So in situations like this where we don't have clear frameworks for challenging a rent increase, we can also consider that SRSs are a consumer dispute. So that would mean that it would be covered by the Australian consumer law, and we may be looking at standard form contracts. We might be looking at half terms. There's very limited case law to tell us around how do we go around this issue, but it's a great example of what I describe as a legislative gap. It's something that the government could look at and say, there's a framework if I'm in specialist accommodation, there's a framework in pretty much any other renting framework, but not for SRSs. We can use general dispute provisions under the Australian Consumer Law to raise those issues and to ask the questions. But it's difficult in terms of many renters may not feel safe to do so. It may be legally complicated, but as a starting point, it's important to reach out for advice. So we often come across these sort of issues where we're not sure. I had to look this one up myself and say, well, how would I raise this issue? So if you come across an issue or something in an SRS, again, you might be able to reach out to Villa Manta Mental Health Community Legal Centre, or you could contact Tenants Victoria as well. It's a really important cohort that many of the people living in these environments, there's a lot of intersectionality and there's a lot of commercial pressures. As I said, it used to be called the SRS Proprietor Act, and obviously it's a really important service for the people living there. And the supports and, whether it's medication or it's the things being explained, if we want to make sure that we are genuinely advocating for the community with disabilities, we want to make sure that we're making a fair system. So there are obligations in that legislation to make sure that things are explained simply, but it's very hard to explain simply if there's not a process that people can use. So thank you for the time you've made to listen to these things. I sometimes am called the encyclopedia, but I definitely don't know it all. And things are rapidly changing, and they're changing in response to the many people in our community that are in need, and also recognise that there are better ways. It doesn't have to be this way, and the government is open to listening to what can be done. That means exploring all the options to make sure that people can have a home, that we can be safe, that we can be productive, that we can recover. Often people say that, home is where we go to unbaggage, because life is tricky. And, again, we thank you as frontline workers for journeying alongside people often for many, many years, as we all sort of try to make our way, and also for the next generation. So for the people that are older, we heard the Minister talk around the importance of supporting older persons. We know with the current state of the economy, retirement is really difficult. We know for young people, facing $1 million median house price is difficult, but it's not something that always has to be this way. And we all have the power to change that.